I'm Deputy Public Defender Oscar B. Rowe here with a lesson on California hate crimes. California Penal Code Section 422.55 PC defines hate crime as a criminal act committed in whole or in part because of the victim's actual or perceived disability, gender, nationality, race or ethnicity, religion, sexual orientation, also referred to as the protected classes, or association with a person or group with one or more of these actual or perceived characteristics. A defendant may be charged with interference with civil rights by threat, as contained in California Penal Code Section 422.6. When a defendant is charged with Penal Code Section 422.6, the prosecutor must prove the elements of the crime as stated in jury instructions, Calcrim 1350. 1. The defendant threatened physical violence against a specific person or a specific group of people. 2. The threat would have caused a reasonable person to be afraid because the defendant appeared able to carry out the threat. 3. The defendant used the threat to willfully interfere with, or injure, intimidate, or oppress another person's free exercise or enjoyment of a right or privilege established by the law or Constitution of California or the United States. 4. The defendant did so in whole or in part because of the other person's actual or perceived belonging to one of the listed protected classes. And 5. The defendant intended to interfere with the other person's legally protected right or privilege. The defendant acted in whole or in part because of the actual or perceived characteristics of the other person if 1. The defendant was biased against the other person based on the other person's actual or perceived inclusion in the protected classes previously mentioned. And 2. The bias motivation caused the defendant to commit the alleged acts. If you find that the defendant had more than one reason to commit the alleged acts, the bias described here must have been a substantial motivating factor. A substantial factor is more than a trivial or remote factor. However, it does not need to be the only factor that motivated the conduct. Actual means that a person acts with some type of ill will or bias motivation because of the victim's real status regarding disability, gender, nationality, etc. In other words, a person performs some offense simply on account of that person's characteristic. The term disability is explained in Calcrim 1353. Gender, as used in this section, means sex and includes a person's gender identity and gender-related appearance and behavior, whether or not stereotypically associated with the person's assigned sex at birth. Nationality, as used in this section, means country of origin, immigration status, including citizenship and national origin. Race or ethnicity includes ancestry, color, and ethnic background. Religion, as used in this section, includes all aspects of religious belief, observance, and practice, and includes agnosticism and atheism. Sexual orientation means heterosexuality, homosexuality, or bisexuality. Association with a person or group having one or more of these actual or perceived characteristics includes advocacy for, identification with, being on the ground owned or rented by or adjacent to a person or group or family or community center or educational facility or office or meeting hall, or place of worship or private institution or public agency or library or other entity that has or is identified with people who have one or more of those characteristics. The prosecution will insert a description of the specific right or rights allegedly infringed in Element 3 of the jury instructions. For example, the right to be free from violence or the threat of violence or the right to be protected from bodily harm as contained in Civil Code Section 43.51.7, People v. Lashley, 1991, People v. McKenzie, 1995. Examples of this crime include: Jose threatens violence against his neighbors, who are a homosexual male couple, because of their sexual orientation. Betty hates religion and decides to damage church property during a mass. Perceived means that a person can commit a hate crime in California even if it turns out that the victim did not have one of the characteristics listed. This is true as long as the defendant believed, or perceived, that they did. X. Consider, for example, a case where Amadea commits an armed robbery against a couple whom he believes to be Jewish. He yells anti-Jewish slurs during the robbery, but it turns out that the couple is not Jewish. Nonetheless, because he perceived the couple to be Jewish, he may be charged with Penal Code 211 PC robbery, as well as a hate crime under this law. Reminder that hate speech, without an underlying crime, will likely be legal speech under the First Amendment to the U.S. Constitution. In Brandenburg v. Ohio, 1969, the court ruled that a state may not forbid speech advocating the use of force or unlawful conduct unless this advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. I'm Deputy Public Defender Oscar B. Rowe, and that is your lesson on hate crimes.